Today I'm going to explain the changes to the Medicare hospital discharge appeal process and how these changes affect inpatient hospital providers and the QIO. Some of these changes may seem to be unnecessarily complicated to you. As you probably are aware by now, the changes are the result of a lawsuit, Whitehart versus Levitt. The changes to the process require that providers communicate with patients regarding their discharge plans and that all inpatients whose stay is reimbursed by Medicare will be informed of discharge appeal rights. Details of these changes can be found in the final rule CMS 4105L, which is entitled Notification of Hospital Discharge Appeal Rights. Today we'll cover the changes to the important message from Medicare and how these changes will affect provider and QIO responsibilities and interactions. The new notice and appeal requirements should be implemented starting on Monday, July 2nd. Patients who are in the facility on that day, July 2nd, would be subject to the new notice requirements before they are discharged. So patients who are in the facility on July 2nd should receive the new important message before being discharged. The new important message from Medicare, or IM, replaces the previous important message that was given to Medicare patients upon admission. The new important message, along with the detailed notice, replaces the HIN and NODMAR notices that were previously given to patients who felt they were being discharged too soon. The purpose of the important message is to notify the patient of appeal rights. It's not to notify them of discharge day. Providers are not required to send a copy of the important message to the QIO for monitoring, as was required with the previous HINs and NODMARs. The important message from Medicare is now standardized and contains appeal and liability information. It is given to all Medicare patients and Medicare Advantage Plan enrollees, and it will be given at all inpatient hospitals. In relation to the new regulation, a hospital is defined as any facility that provides care at the inpatient hospital level, and whether that care is short-term, long-term, acute or non-acute, or paid through the prospective payment system or some other reimbursement basis. Even if the hospital is limited to specialty care or providing a broader spectrum is included in the new regulations. And a discharge is defined as a formal release of a patient from the inpatient hospital level of care. All Medicare beneficiaries are included in the new regulations, no matter where Medicare falls in the sequence of payers. Medicaid patients are not included unless they are dual eligible. And beneficiaries with other forms of coverage as the primary payer should also receive the important message notice, no matter where Medicare falls in the sequence of payment. It is not appropriate to provide the patient a copy of the important message in situations that can't be appealed to the QIO, such as a non-covered stay, for benefit exhaustion, or for condition code 44. A notice, such as a advanced beneficiary notice, informing the patient that the stay is not covered or that the status is changing from inpatient, is appropriate in these situations. A new notice for hospitals to use the Hospital Stay ABN or HSABN is expected to be approved and available on the Medicare Beneficiary Notices Initiative or DNI website before July 2nd. The DNI website is an important resource for providers during this transition to the new appeals process, and we will give you that web address at the end of this presentation. Patients admitted directly to swing beds are not given the important message as they aren't receiving inpatient services. The pre-admission or admission HIN or the hospital stay advanced beneficiary notice can be used in this situation to inform patients that the stay is not covered. However, remember that if you give the pre-admission or admission HIN, the patient then has the right to request a QIO review. The important message shouldn't be given for care delivered in the outpatient departments either, such as the emergency department or observation settings, because these are not inpatient settings. The important message shouldn't be given in the rush of the emergency or outpatient department if it is planned that the patient will be admitted as an inpatient. When the patient is admitted as an inpatient, the IM should then be given so that patients can fully understand their appeal rights and not be rushed. If the important message is given during a pre-registration visit, it shouldn't be more than 7 calendar days until the patient will be admitted. The regulations require that the initial copy of the important message be given to the patient within 2 days of the inpatient admission. A follow-up copy of the important message is given to the patient as soon as possible when the discharge is planned, but it shouldn't be given any more than 2 days before the discharge. Regarding the discharge date, during the period of public examination of these notices, there were many comments to CMS indicating that it was difficult to determine when the exact date of discharge would be for a specific patient. So the date of discharge is not included in the important message that providers give to the patient. If the patient asks for appeals, they will receive a detailed notice from the provider that will contain the discharge date. If they don't ask for an appeal, they will receive a liability notice, and it will have the discharge date on it. Patients should be given at least 4 hours prior to discharge to consider whether or not they want to appeal. Now, most patients will not need 4 hours to consider their appeal rights. And, of course, a patient may go home anytime they are willing. However, they should not be pressured to leave prior to be given at least 4 hours to request an appeal. And routine delivery during the rush to make discharge arrangements should be avoided if at all possible. Let's discuss the timing of the follow-up copy of the important message from Medicare. For a brief admission, the follow-up copy may not be required. If the initial copy is given within 2 calendar days of discharge, you wouldn't have to give another copy. For example, if the patient is admitted on Monday and the initial copy of the important message is given on Wednesday and the patient is discharged on Friday, the follow-up copy would not be required as the initial copy would be both within 2 days of admission and 2 days of discharge. If the initial copy was given during a pre-admission registration and more than 2 calendar days have elapsed, a follow-up copy of the important message is required even if the admission only lasts for 2 days. So, say an initial copy is given on the 7th during a pre-registration visit, and the patient is admitted on the 10th and is discharged on the 11th, the provider would give a follow-up copy of the important message prior to discharge. inpatient to inpatient transfers. If the patient is transferring to another acute inpatient care setting, the follow-up copy of the important message is not required. The receiving facility, and that would be different from a receiving unit within the same facility, would deliver the initial copy of the important message again after transfer to the new facility. For Medicare purposes, if the unit is billing with the same provider number, it would be considered a transfer within the facility and not a discharge. If the patient is transferred to a unit with a different provider number, the transfer would be considered a discharge. A transfer or discharge from one inpatient hospital setting to another inpatient hospital setting does not require the follow-up copy of the notice prior to leaving the original hospital, since this is considered the same level of care and the appeal rights do not apply. However, if the inpatient transfer involves discharge from one inpatient facility and readmission to another inpatient facility that is billed with a different provider number, the receiving hospital must deliver the important message from Medicare again. Most patients will not question their discharge and are anxious to go home. However, if the patient that is being transferred to another acute inpatient setting is usually agreeable to receiving further care. One result of the changes to the processes is that after receiving the important message, patients may ask more questions about the discharge or transfer plan. As with the previous HIN process, it is not appropriate to issue a HIN when the patient questions transfer to a long-term rehab or other acute care facility, as HIN regulations and review address discharge and liability and not appropriateness of the treatment plan. If the patient does question an inpatient transfer, the provider should utilize a case management approach to explore options with the patient and the physician and work out a plan that is agreeable. The patient always has the right to refuse care or contact the Quality Improvement Organization if they have a quality of care concern. There are valid delivery requirements associated with the new regulation. The important message number is CMS R193, and it can be found on the CMS Beneficiary Notices Initiative website. For Medicare, the only modifications that can be made to the important message and the detailed notice are adjustments to the spacing at the top and bottom, and the items in the header can be moved around to accommodate a patient label. Items can't be removed or reformatted in the body of the notice in any way other than is stated in the instructions. This would prohibit changes like moving the signature line and adding the hospital logo. Valid delivery requirements include signing and dating by the patient to show that they have understood the notice. If the patient can't sign and date the notice, it has to be an acceptable representative. To meet valid delivery requirements, the important message must be delivered within the time frames previously explained. Medicare has said that valid delivery of the important message and ensuring that beneficiaries are informed of appeal rights is more important than who gets the original copy of the notice and how the follow-up delivery is done. So any method of notice delivery that provides a legible copy for the patient or representative and retains a copy for the record is acceptable. If it is more convenient for the provider, the patient can be asked to sign a new blank copy at the time of delivery of the follow-up copy that is associated with the discharge. If the patient refuses to sign, after the form and appeal rights are explained to them. Note the date of refusal in the record as the date of receipt of the notice and leave the notice with the patient. You should see the Medicare Claims Processing Manual, Chapter 30, Section 200, that contains instructions, and this is also posted to the Medicare Beneficiary Notices Initiative website for further information about valid delivery requirements. The person deemed by the hospital to be a valid representative must be acting in the patient's best interest or possess written authorization or as otherwise is acceptable to make health care decisions under your state guidelines. It's preferred that the important message be delivered in person either to the patient or to the representative. If a patient has no family or responsible person, the provider should contact the appropriate agency in your state. But you can't assign liability to the patient without valid delivery of the important message to a representative acting for the best representative acting for the best interest of the patient. If the important message has to be delivered by telephone, someone must speak directly to the representative regarding the appeal information contained in the important message. When they're notified by phone, all aspects of the important message should be explained. And a written notice should be mailed or faxed on the same day that the representative is informed of the appeal rights by telephone. If there are problems contacting a representative, you should keep a record of all your attempts and document this in the medical record. If you're unable to deliver the important message by phone, it can be sent via a system that requires a signature for delivery. The date of delivery would be considered the date it was signed for as accepted, or the date the provider was informed that delivery of the letter was refused. So whenever you tracked that letter for signature and found out that someone had refused to sign it, that would be the date it would be considered as delivered. QIOs will accept patient requests for discharge appeals 24 hours a day and will perform these appeal reviews 7 days a week. QIOs will have a system in place to use voicemail or an answering machine after regular business hours. This aligns Medicare hospital appeals with Medicare non-hospital appeals. And providers should contact your QIO to find out the telephone number that should be listed on the important message to ensure that there's valid delivery of the notice and also to prevent delays in initiating discharge appeals. The Medicare patient or representative may request a discharge appeal anytime they are informed of a planned discharge. Usually this will happen after being given the follow-up copy of the important message within 2 days of discharge. They must be contacted before midnight on the day of the planned discharge. For the patient to be protected from liability, the QIO must be contacted before midnight on the day of the planned discharge, meaning on the day that the discharge is ordered. When contacted, the QIO notifies the hospital for an original Medicare beneficiary or the MA plan for an MA plan enrollee as soon as possible that an appeal has been requested. If the request for appeal is received after hours, the QIO will contact the hospital or MA plan first thing the next morning. A detailed notice is then issued to the patient. The number of the detailed notice on the BNI website is CMS 10066. This notice is issued by noon of the next day. The MA plan may delegate issuance of the detailed notice to the hospital, but it should be issued by noon of the next day. The detailed notice is an OMB approved notice, and like the important message, this detailed notice cannot be modified. The detailed notice must contain specific information about the patient's medical condition, explained in simple terms that a lay person can understand. During the discharge appeal review, the QIO will determine if the important message and the detailed notice were validly delivered by the provider or the MA plan. The QIO and provider or MA plan will coordinate to decide what information is needed to complete a specific discharge appeal. Any and all information that the QIO needs to make the determination should be provided by noon of the next calendar day. The MA plan is responsible for providing the information needed to make a determination for an MA plan enrollee appeal. If the patient requests a copy of the documentation that is to be sent to the QIO or was sent to the QIO, the provider or MA plan may charge a reasonable fee to cover the cost, but should provide the information by no later than the first day after the material is requested. As part of the discharge appeal, the QIO will require documentation and verification from the patient or representative that the notices were validly delivered. If a skilled nursing facility bed is needed for transfer, the copy of the important message that is delivered within 2 days of the discharge shouldn't be given until a SNF bed is available. There must be a SNF bed available for the provider to assign liability to the patient. QIO responsibilities include contacting the hospital, patient, attending physician, and the MA plan for information and comments related to the patient's condition and the plan discharge. After the expedited determination decision is made, which should be within 1 calendar day, the QIO contacts the parties by phone and notifies them of the determination. A written notice is then sent to the hospital, the patient, the attending physician, and the MA plan if appropriate. The patient is protected from liability during the timely expedited discharge appeal process. After being notified by the QIO, if the patient remains in the hospital, they would become liable beginning at noon of the next day. Of course, if the QIO disagrees with the discharge, the stay continues to be covered by Medicare or the MA plan. If the patient remains in the hospital and doesn't request appeal in a timely manner, meaning by midnight on the day that the discharge was ordered, they may still request expedited appeal. Patients with original Medicare will contact the QIO. Patients with MA plan coverage will contact their MA plan for an untimely request for discharge appeal. When the QIO receives the request for an untimely appeal from an original Medicare beneficiary, the provider in the QIO will follow much the same process as for a timely request for appeal. The QIO will contact the hospital, the patient, and the attending physician for comment. The facility will provide the detailed notice to the patient and all information that the QIO needs by noon of the day after being contacted by the QIO. However, if the request for appeal is untimely, the QIO will make the determination and notify the involved parties within 2 calendar days. And a patient is not protected from liability during an untimely appeal. The liability for the patient would begin the next day after the discharge date. After leaving the facility, the patient has 30 days to request a discharge appeal. If the patient has good cause, the QIO can accept their request for a discharge appeal after these 30 days have elapsed. If the patient has left the facility when the request is made, the facility has 30 days to provide the detailed notice to the patient and to forward the information to the QIO. If the QIO doesn't receive the information that's needed to process the appeal, the admission would be subject to technical denial as with any other record request. After the QIO receives all the information that is needed to make a determination, the QIO has 30 days to make that determination and to notify all the involved parties. If a beneficiary does not request an appeal after being informed of the discharge plan and discharge date, and they're an original Medicare patient and stay in the hospital should issue a limitation of liability notice, or ABN, Advanced Beneficiary Notice. There will be a new hospital stay ABN released soon that can be used for this purpose. The MA plan is responsible in this situation for the denial notice that is given to the plan enrollee and for giving guidance to the enrollee about the plan's expedited appeals process. And the liability in this situation would begin the next day after the discharge has been ordered. If the Medicare beneficiary or plan enrollee requests reconsideration of the QIO decision after a timely expedited discharge appeal, the provider may not bill the patient until the reconsideration determination is complete. The timely request for the reconsideration should be made by noon of the day following the QIO notification. If there's an untimely request for reconsideration, it will follow the standard claims appeal process. However, a reconsideration will not affect the patient's liability from the original determination unless it is overturned. The changes to the regulations that are found in CMS 4105F require QIOs to accept requests for appeals 24 hours a day and perform reviews 7 days a week when the request is from hospital inpatients who are being discharged. However, the changes do not affect requirements for QIO availability to perform pre-admission, admission hints, and hospital-requested reviews. QIOs are required to accept hospital requests for pre-admission, admission hints, and hospital-requested reviews, during regular working hours, Monday through Friday. The time frames that are related to when a hospital can issue a pre-admission admission hand and when the patient can request an appeal and regarding the liability for the stay are unchanged from the previous process. It is not appropriate to issue the important message from Medicare to a patient if it is planned to issue a pre-admission admission hand, unless the patient is later admitted to inpatient status, at which time they would receive the important message. There's a new recommended notice to be used when the patient is admitted for services that are thought to be not reasonable and necessary. This notice can be found on the Beneficiary Notices Initiative website. Delivery of this notice is affected by the new notice requirement, meaning the pre-admission, admission notice of non-coverage must be validly delivered to a patient who can understand or to a representative acting in the patient's behalf before any liability can be assigned. The patient will be informed of the review determination and reconsideration process by the QIO by telephone, followed up in a letter. There's also a new hospital requested review notice to replace HIN 10. This notice can be found on the BNI website. Although use of the new notices for pre-admission admission HINs and hospital requested review aren't mandated, it is recommended that the suggested language and format be followed so that there won't be questions about valid delivery and understanding of the notices. After July 2nd, the policy at CMS will change, and hospitals can request QIO concurrence regarding discharge of MA plan enrollees. It's expected that providers and MA plans will discuss this beforehand before using this process. The hospital is responsible for the burden of proof related to the patient's readiness for discharge if they request a review of an MA plan enrollee or a Medicare beneficiary. The hospital provides the information to the QIO, and as with the previous request for QIO concurrence, the determination is made within 2 working days. The patient becomes liable on noon of the day after QIO notification. This is the same for all hospital requested reviews. The important message associated with the plan discharge would not be given in this situation. QIO notifies the involved parties and solicits comments as with the other discharge appeals. The patient, provider, attending physician, and MA plan are notified of the determination within 2 days. It is not necessary for the provider to issue another non-coverage notice to the patient after the QIO determination, nor is it necessary to give the patient another copy of the important message prior to discharge. The patient will receive a letter from the QIO after the phone notification that explains the reconsideration process and the liability. This concludes our presentation about the new hospital discharge appeals process. Information about changes to the hospital discharge appeals process can be found on the CMS website at www.cms.hhs.gov/BNI. You go to the site, and under the Beneficiary Notices Initiative, website, go to the link for hospital discharge appeal notices. It's on the left side of the screen. You should check the site often for updates because there will be some new transmittals and instructions down there. There's updates to the Medicare Claims Processing Manual there, and there's copies of all the required notices and the suggested notices. There's also a website you can submit questions to directly, YCART_ODS, that stands for Open Door Forum, at cms.hhs.gov.